Chairman, or last, or what's our plans?
Oh, well, let's see how we go.
All right, thank you. Well, it's been a long day for you. Thanks
It's
for
been
being
a
here.
lot, yeah, and I am concerned about the witness and her stamina. Mine's,
Her reputation says she's tough as nails. She can make it. First of all, you do get the Arthur Murray Award. You are dancing a little bit, much to my chagrin. I would rather you not win. Maybe you should be on Dancing of the Stars or something. I want to go first to a couple areas. One of the people I respect most in the Senate is somebody that's a polar opposite of me. His name's Russ Feingold, and he's unabashedly stands for his liberal positions, defends them, doesn't run away from them, talks about them, and stands up and beats his chest because he thinks he's right. And I've never walked away from my conservative positions. I don't apologize for my social conservatism or my fiscal conservatism. And one of the things I told you, I want America to know who you are. And you know, you've kind of not allowed us, you know, I don't know what a liberal progressive is. I know what a liberal is, and I think you're a liberal. I think you're proud enough to defend that. And as Senator Graham said, there's nothing wrong with that. But the point is you have a very different belief system than most of the people who come where I come from. And it's not wrong to have that belief system. It doesn't mean mine's right and yours wrong, but it is wrong for us not to know what you believe about a lot of things. You're very pro-choice. You believe in a woman's right to choose. You believe in gender mixed marriages or gay marriage. You believe that states ought to recognize those throughout. If I say something that is inappropriate, please tell me.
Well, Senator Coburn, I suppose what I would want to say at this point is that the way I would vote as a legislator with respect to any or all of those issues.
I'm not trying to label as a judge. I'm just saying it's important. I'm not saying you are not going to have the capability to separate those positions. I'm not saying that. But it is important. I mean, you've told this committee that you think that there is appropriate time to use foreign law. You told this committee that in your Solicitor General testimony in terms of answers to questions.
Can I interrupt you on that one too?
Well, I'll give you a chance. You have made statements for assisted suicide in terms of that being an appropriate thing. So I'm not saying that will limit your ability to make great decisions as a jurist. And I want to separate that right now. But I don't want us to know. The American people have a right to know what make up Elena Kagan. There's all these other characteristics too. Smart as all get out, super accomplished, tough as nails. I believe you're tough as nails. I would not want to be a Supreme Court justice with you. I think I'd get run over. You know, I believe you have the intellect, superior intellect, and ability to reason. And I've listened to a lot of it here. And again, there's nothing wrong. I love Russ Feingold to death, but we're totally different. And that's one of the things that makes our country great. But it's not something that I don't want you to run away from that. That's who you are. That's what you've fought for a lot of causes in your life. And those are a part of who you are. And a part of who you are will, in some small instance, influence your judge. I don't know one judge that can 100% separate themselves from who they are as they make a decision. And I don't think anybody knows a judge that can do that. So it's not unfair to say who you are. And it's not a slam at all. It's just you're different than me and you're different than many of the people that I represent. So I wanted to establish that, and I want to give you a chance. If you want to say something in response to that, I'll be happy to give you that chance right now. But, you know, I'm a proud conservative. I'll fight anybody I'm for it. I'll debate anybody about what I believe and why I believe it. And I think you would do the same. And that's one of the reasons I have admiration for you. Do you have a comment about what I've said?
Well, I suppose a few comments, Senator Coburn. Let me take on just a couple of the particulars and then maybe make a more general comment. You said as Solicitor General, I advocated the use of foreign law in some circumstances, and I do just want to make clear that what I said in those questions.
Here's your quote. Exactly.
Was that because there are justices on the Supreme Court who believe in the use of foreign law in some circumstances, that I would think it was appropriate as an advocate to argue from foreign law or to cite foreign law in any circumstance.
Well, but that isn't what you said here.
Well, I think Senator Coburn, with all respect, that if you look at the question and if you look at the answer, I was speaking in my role as an advocate, saying that the primary consideration of an advocate is to count to 5 and to try to do the best the advocate can to ensure that the position that the advocate is taking will prevail.
But it's not your position because some other justices are using foreign law. You have the authority to do that as well.
As an advocate, to the extent that I think that foreign law arguments will help the government's case, then I will use those foreign law arguments.
All right. Let me read something to you. As is obvious, I'm not a lawyer. Okay, it's pretty obvious. But Article 3, Section 2 says this: the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and the treaties made. Nowhere in our Constitution does it give the authority for any judge, Chief Justice of the Supreme Court, any jurist on the Supreme Court, or any other court, to reference foreign law in determining the interpretation of what our statutes or our Constitution will be. So this is an area where we have grasp, where our judicial majority, much like the Israeli judge, that we start reaching beyond the Constitution. You said it was all law. You said the determination will always be law. It's down to law. The earliest questions that you were asking in this hearing. Well, this is the founding document of what the law is. Nowhere that I can find in this writing or in these guys' writing says anything about using foreign law. So please explain to me why it's okay sometime to use foreign law to interpret our Constitution, our statutes, and our treaties.
Senator Coburn, I think for the most part, I wouldn't try to convince you of that because I don't think that foreign law is appropriate as precedent or as an independent basis of support in the vast majority of legal questions. Now, I suggested to you a few that specifically might reference international considerations, such as, the right to receive ambassadors or something like that. Even there, I think the citations would not be a precedent. They would not have binding weight of any kind, but they might be relevant to interpretation of
relevance is about getting knowledge and gaining knowledge. But there's you have a different guide. The oath that you'll take as a justice of the Supreme Court is to uphold the Constitution and our statute.
Well, I think I agree with you on that, Senator Coburn.
Don't worry, I will never get there. All right, let me move on then, if I may, if I can keep playing. One of the things that you said today really concerned me, and let's see if I've got that. You were being asked a question. And you said, but in other cases, original intent is unlikely to solve the question. And that might be because the original intent is unknowable. Or it might be because we live in a world that's very different from the world in which the framers lived. In many circumstances, precedent is the most important thing. Is the precedent more important than original intent?
Well, Senator Coburn, let me give you an example. I'm not sure if it was an example I used before or not, but in the First Amendment context, which is a context I've written about a good deal, it's fairly clear that the First Amendment doctrine that's been established over 100 years departs significantly from the original intent of the framers. And here's one example, is that I think that the framers would never have dreamed that the First Amendment would in any way protect people against libel suits, that the First Amendment had anything to do with libel. So when the court said in New York Times v. Sullivan that a public figure could not sue the New York Times and claim damages for libel, without meeting a very high bar, without meeting the so-called actual malice standard. I think that that was something that the framers would not have understood. Now,
Why would you think they wouldn't have understood that? I mean,
Well, I think that
they had print back then. I mean, we didn't start that early in terms of formation of our country.
I'm sorry for interrupting. I think that the historic evidence is very clear that the framers didn't think that the First Amendment at all interfered with libel suits. Now, over time, as courts have applied the First Amendment to different contexts, to different circumstances, have seen different factual problems, have had to consider different cases, I think that the courts sensibly thought that the principles that are embodied in the First Amendment could not be protected unless the decision in New York Times versus Sullivan was issued, unless
So let me go forward with that. Who can change precedent?
Well,
Let's have a little law lesson here. Who can change precedent?
well, the court can, but it's a very high bar.
I know, but they can, right?
The court can overturn a ruling, but it's a very high bar. The precedent.
What does a high bar mean to the average person watching this hearing today?
Well, it has to be a very extraordinary circumstance or a very unusual circumstance for a court to overturn a precedent. And the usual circumstances that are mentioned are where the precedent has become completely unworkable, where it's clear that the precedent just is producing massively inconsistent results. Or
So, for example, Brown versus Board of Education, that upset precedent, Plessy versus Ferguson, on its ear, didn't it?
It did, Senator Coburn. I think that.
So what was the purpose in changing the precedent? Was it to change Plessy versus Ferguson, or was it to go back to original intent? That's where I'm having trouble with what you said, because, I know our framers weren't perfect, but I think their motivations were really pure. And for us to have a justice that says precedent is more important than original intent is going to give a lot of people in this country heartburn, because what it says is our intellectual capabilities are better than what our original founding documents were, and so we're so much smarter as we've matured that they couldn't have been right. And that's dangerous territory for confidence in the court.
Senator Coburn, I think what I'm trying to say is that courts appropriately look to both keys to constitutional interpretation, that courts appropriately look to original intent, that courts appropriately look to precedent, and that it depends on the provision of the Constitution, it depends on the case, it depends on the issue, as to which one of those is most helpful, and that it's a pragmatic approach, looking case by case to try to figure that question out. And I think what I'm saying, I would say two things about it. It's both extremely descriptive of what the court has done, that the court
historically speaking
and currently. And the second point I would make is that, in fact, when the Chief Justice was sitting here, Chief Justice Roberts, he stated the same thing. The same principle that I'm trying to state is that one should approach the question of constitutional interpretation and pragmatically, without a single overarching theory, without something that says you always look to the specific original intent, or you always look to something else. That sometimes the original intent controls, and other times it may be unknowable, or it may be far removed from the current problems we face.
But that's a judgmental decision, correct? You're going to make a judgment about whether original intent doesn't apply or is unknowable. And what may seem to be unknowable to you may seem to be knowable to another judge, correct?
Senator Coburn, I don't disagree with you that judging requires judgment.
Yeah.
Well,
that's the whole basis why we're having this hearing, is where's the judgment going to come from? Because it takes me to the next thing that you said that I have heartburn with. I have great difficulty in the ability to take off my advocate hat and put on my judge's hat. And my question to you is, I would have the same problem. I will tell you, how are you going to take off your political hat? What are the processes with which Elena Kagan is going to take off this advocacy of a liberal position in this country as she becomes a justice of the Supreme Court, so that that advocacy hat is gone and only the judgment hat is left? How are you going to do that? You've already admitted you have trouble doing that now, just from a Solicitor General standpoint.
So, Senator Coburn, the advocate's hat that I was referring to was not a political hat. It was the hat that I wear as Solicitor General of the United States, representing the interests of the United States. That has nothing to do with my own political views. It has to do with a long and historic tradition that the Solicitor General's office has of representing the long-term interests of the United States government.
Well, then let's move back to your political hat. How are you going to take that off?
Senator Coburn, that hat has not been on for many years. Senator Coburn, I know that, some people have said, oh, she's a political person. I've had a 25-year career in the law. Of that 25-year career, 4 were spent in the Clinton White House. This was a period of time that I am proud of, and that I feel as though, I helped to serve the American people for President Clinton. But this is by no means the major part of my legal career. The major part of my legal career has been as a scholar and teacher of constitutional and administrative law, has been, teaching, by this point, many thousands of students, has been writing about constitutional and administrative law issues.
Let me ask you another question then on it. And this is the Inquirer. This is a softball, okay? What do you say to...
Promise?
I promise. What do you say?
Because it's getting late.
I told you, you're terrific. What do you say to people who are worried that your political positions would influence your judicial opinions? What do you say to the average American that's sitting here watching this right now? What assurance, and other than knowing Elena Kagan, that, we know who you are, we've met you, we've read about you, both positive and negative, what are the assurance that you'd tell the American people is you can trust me to make a pure jurist decision, that I'm not going to be biased? What is it that you would tell them?
Well, I hope that they would listen to this hearing and come away with that view, come away with a person who believes that it's all about law when you put on a judge's robe. It's not about politics. It's not about policy. It's all about law and making your best judgments about what the law requires. And that is the pledge that I said was the only pledge that I would make yesterday. And I'll make it again now. But I think it's consistent with the way I've approached my life, in a fashion that respects the rule of law, in a fashion that's temperate and respectful of other people's views, with respect, which I don't think is partisan in the kinds of ways that a few people have suggested.
You can understand why some of us, when Justice Sotomayor told us, her words was, I think I agree with you, Senator Coburn, we shouldn't use foreign law. And then one of her opinions, she's embracing the use of foreign law on a decision. We become skeptical because, and as I said earlier, and as I said in the floor speech about these hearings, is, it really isn't going to matter what you said, because once you're there, and we have very little ability to change it. And so when we see histories and then we see statements that don't coincide, and quite frankly, you haven't done that to us that I know of yet today. But you can understand the skepticism we might have, and especially in the fact that many on the other side of the aisle, the implication has been that the same thing by Alito and Roberts, that they weren't straightforward, that in fact they didn't keep their word on stare decisis, So you understand what we're battling with, and that's why I'm not even sure the hearings are a great thing. I think we ought to do it the way we used to do it, is sit down and talk and spend a lot of time with you and get a comfort level where we feel like we really get to know you and what you believe and what your actions will be. Let me go to one other thing. Senator Cornyn attempted to ask this, and I think it's a really important question. If I wanted to sponsor a bill, and it said, Americans, you have to eat 3 vegetables and 3 fruits every day. And I got it through Congress, and it's now the law of the land. You got to do it. Does that violate the Commerce Clause?
Sounds like a dumb law.
Yeah, I got one that's real similar to it I think is equally dumb. I'm not going to mention which it is.
But I think that the question of whether it's a dumb law is different from the question of whether it's constitutional. And I think that courts would be wrong to strike down laws that they think are senseless just because they're senseless.
Well, I guess the question I'm asking you is, do we have the power to tell people what they have to eat every day?
Senator Coburn, I
mean, what is the extent of the Commerce Clause? We have this wide embrace of the Commerce Clause, which these guys who wrote this never, ever fathomed that we would be so stupid to take our liberties away by expanding the Commerce Clause this way. Matter of fact, let me spend I've got a little time. Let me just read you what they said, because they actually said if the executive branch and the judiciary branch wouldn't enforce their limited view of the Commerce Clause, that in fact we needed to change the members of the Congress so that they would. And let me read it to you. If it be asked what is to be the consequence in the Congress.
Senator Coburn, where is this from?
This is the Federalist Papers.
Okay.
Okay. This is number 44. I presume you've read this book?
I have.
I thought you might have.
It's a great book.
It is. Actually, I hope you'll read it a lot as a justice if you become one. Constitution, exercise powers not warranted by its true meaning. They're sitting there warning us to not do things. What are you going to do about it? And I answer the same as if they should misconstrue or enlarge any other power vested in them, as if the general power had been reduced to particulars and any one of these were to be violated. The same, in short, as if the state legislature should violate their respective constitutional authorities. In the first instance, the success of the usurpation will depend on the executive and judiciary departments. In other words, you become complicit in not slamming it down and saying, Congress, you're going the wrong way. And I would make the case today that we find ourselves in trouble as a nation because the judiciary and the executive branch has not slapped Congress down on the massive expansion of the Commerce Clause, which are to expound and give effect to the legislative acts. And in the last resort, a remedy must be obtained from the people who can, by the election of more faithful representatives, annul the acts of the usurpers. So I go back to my original question to you. Is it within the Constitution for me to write a bill, having been duly elected by the people of Oklahoma, to say, and get it signed by the president, that you have to eat 3 fruits and 3 vegetables every day?
Well, Senator, first let me say about the Federalist paper quote that you read, that it is absolutely the case that the judiciary's job is to, in Marbury v. Madison's famous phrase, to say what the law is, and to make sure, I think I've talked about it as policing the constitutional boundaries and making sure that Congress doesn't go further than the Constitution says it can go, doesn't violate individual rights, and also doesn't act outside its enumerated authorities. We live in a government in which Congress's authorities are enumerated in Article 1 of the Constitution, and Congress can't act except under one of those heads of authority. Now, as I talked about with Senator Cornyn, the Commerce Clause has been interpreted broadly. It's been interpreted to apply to regulation of any instruments or instrumentalities or channels of commerce, but it's also been applied to anything that would substantially affect interstate commerce. It has not been applied to non-economic activities, and that's the teaching of Lopez and Morrison, that the Congress can't regulate non-economic activities, especially to the extent that those activities have traditionally been regulated by the states. And I think that that would be the question that the court would ask with respect to any case of this kind. But I do want to sort of say again, we can come up with sort of, just ridiculous sounding laws, and the principal protector against bad laws is the political branches themselves. And I would go back, I think, to Oliver Wendell Holmes on this. He was this judge who lived, in the early 20th century, hated a lot of the legislation that was being enacted during those years, but insisted that if the people wanted it, it was their right to go hang themselves.
Okay.
Now, that's not always the case, but there is substantial deference due to political.
I'm running out of time. I want to give you another condition. What if I said that if eating 3 fruits and 3 vegetables a day would cut healthcare costs 20%? Now we're into commerce. And since the government pays 65% of all the healthcare costs, why isn't that constitutional?
Well, Senator Coburn, I feel as though the principles that I've given you are the principles that the court should apply.
Well, I have a little problem with that, because if we're going to hang ourselves, and as our founders, 3 of the critical authors of our Constitution thought the judiciary had a reason to smack us down, and as Oliver Wendell Holmes, if we want to be doing stupid stuff, we can do stupid stuff. I disagree. I think, and that's not activism. That's looking at the Constitution and saying, oh, we're going to ignore it even if it does expand the Commerce Clause, because the Commerce Clause is what has gotten us into a place where we have a $1.6 trillion deficit, that our kids' future has been mortgaged, what we may never recover from. That's not an understatement at all. In 25 years, each of our kids are going to owe $1,113,000 before they pay interest on that before they do anything for themselves or their kids. So the fact is that we have this expansive clause, and we have to have some limit on it. And if the courts aren't going to limit it within the original intent, instead of continuing to rely on precedent of this vast expansion of it, the only hope is that we have to throw out most of the Congress. But the point is their original intent is that you wouldn't ignore their original intent. And what we find ourselves today on the Commerce Clause is that through a period of precedent-setting decisions, we have allowed the federal government to become something that it was never entitled to become. And with that, a diminishment of the liberties of the people of this country, both financially and in terms of their own liberty.
Well, Senator Coburn, I guess a few points. The first is I think that there are limits on the Commerce Clause of the ones I suggested, which are the ones that were articulated by the court in Morrison and in Lopez, which are primarily about non-economic activity and Congress not being able to regulate non-economic activity. I guess the second point I would make is I do think that very early in our history, and especially I would look to Gibbons v. Ogden, where Chief Justice Marshall did in the first case about these issues, essentially read that clause broadly and provide real deference to legislatures and provide real deference to Congress about the scope of that clause. Not that the clause doesn't have any limits, but that deference should be provided to Congress with respect to matters affecting interstate commerce. And I guess the third point is just to say that I think the reason for that is that $1.6 trillion deficit may be an enormous problem. It may be an enormous problem, but I don't think it's a problem for courts to solve. I think it's a problem for the political process to solve.
You missed my whole point. We're here because the courts didn't do their job in limiting our ability to go outside of original intent on what the Commerce Clause was supposed to be. Sure, you can't solve the problem now, but you helped create it as a court because you allowed something other than what our original founders thought was a legitimate role for the federal government.
I
thank you, Chairman. I will yield back, and I'll follow up on the next round.
Yield back. Your time is up, but I didn't know whether you wanted to respond to that. Did you want to take a break before we go to some of the others, or?
Some of the others. If it's some of the others, I definitely want to take a break. If